Today we're talking about something that may surprise a lot of people, and that is, even if you write a will, state laws still sit quietly in the background, not to take over your plan, but to fill gaps, interpret unclear parts, and protect certain people when life gets messy. And life does get messy. Families change, assets change, people move. A will that sounded perfect 5 years ago could land differently today. So in this lesson, we are going to look at the ground rules. A will lives within a framework of state laws that may interpret, change, or even override parts of what you've written. So today, you're going to learn the main default rules your state may use. Think of these state statutes like the rules of a card game. You have to play the hand you're dealt, but if you really know the rules, you can give yourself and your family a significant advantage. Most of these laws aren't there to hinder you. They are designed to protect your beneficiaries, especially your spouse and children, and to provide a backup plan when a will is silent or unclear. And don't forget this truth, which we touched on in an earlier lesson. It is the laws of the state where you are a legal resident at the time you die that govern your estate, not necessarily the laws of the state where you lived when you first signed your will. If you move to a new state, please revisit your plan to ensure it still works the way you intend under your new local rules. Here are some of the common statutes that act as a helping hand in the background of your will. The first is called abatement. Think of abatement as, there's not enough in the cupboard for everyone. If the estate can't pay debts and fulfill every gift in full, state law may set an order for what gets reduced first. Usually, the leftovers or residuary estate are reduced first to pay creditors before the specific gifts you've listed are touched. A great strategy to keep these rules from surprising your heirs is to use percentages instead of fixed dollar amounts, allowing your wishes to scale with the size of your estate. Next is a concept called ademption. This one is about missing property. If your will says, I leave my baseball card collection to my son, but you sold it years earlier, that gift may fail. In most cases, if the item is gone, the gift simply fails, and the person receives nothing. You can stay ahead of this by naming backup gifts or including language that provides a cash equivalent if the item is missing. There's also the anti-lapse statute. Life is unpredictable, and sometimes a beneficiary might pass away before you do. If your will doesn't say what happens next, anti-lapse laws might step in to direct that gift to that person's own children, keeping it within their family line. If your state doesn't have this law, the gift might instead fall into your residuary estate. Many states also have laws that handle major life changes like divorce. In many states, if you get divorced but forget to update your will, the law automatically treats your ex-spouse as if they had died before you, effectively removing them from the document. However, you shouldn't rely on this alone. It is always best to update your documents and your beneficiary forms on things like life insurance to ensure there is no confusion. What if you and a loved one pass away at the same time or close enough that the order can't be established? Simultaneous death statutes provide a default rule so that your assets don't have to go through the probate process twice in a very short window, which can save your family a lot of time and money. You can even add a survival clause to your will, requiring a beneficiary to outlive you by a certain number of days, like 30 or 60, to receive their inheritance. Now, there are some laws that your will generally cannot change, particularly when it comes to protecting a surviving spouse. If you live in a community property state, the law may view any assets acquired during your marriage as being owned 50-50 by both spouses. In other states, spousal elective share laws ensure that a surviving spouse can claim a specific portion of the estate, often 1/3 to 1/2, even if the will says otherwise. These laws exist to make sure a spouse isn't left without support. Some states even consider an augmented estate, which is a way of calculating the spouse's share using a bigger picture than just what goes through probate. Similarly, homestead and family allowance statutes may protect your family's right to stay in the family home and receive temporary financial support for daily living expenses while the estate is moving through the court system. These are some of the only payments that can often be made before creditors are paid, providing a vital safety net during a difficult time. Then there is the law that protects people who are accidentally left out of the will, such as pretermitted heirs. If a spouse or child isn't mentioned in a will sometimes, the court may assume it was a mistake and award them a share of the estate based on state default rules. And finally, some rare states have forced heirship statutes. These require certain heirs, most notably in Louisiana, to receive a minimum share of the estate regardless of the will. So, here's the vital perspective shift for today. You don't have to be a legal expert to see how these statutes might impact your goals. Instead of seeing state law as a threat, see it as a set of guardrails and default settings. Guardrails can prevent major harm, but default settings aren't the same as your personal wishes. Because every state is unique and these rules can be complex, if you intend to override any of these standard statutes, or if your plan involves intentionally excluding a spouse or child, it is wise and highly recommended to seek professional legal advice. An attorney can help you use specific language to ensure your unique intentions are the ones that are followed. By learning about these background rules, you are building a more resilient and effective roadmap for your loved ones. If you are ready for a small immediate step, complete the questions below this video in your MyEstateKit app. For those who want to dive deeper, there are optional resources that can help you compare high-level differences between states and build a list of questions for a qualified estate planning professional. Not because you have to, but because having the right questions can save time, money, and confusion later. You're doing the hard work of planning for the details, so keep going. You're doing great.